became noticeably more hostile to surveillance, no doubt in part because memories of the disaster on September 11, 2001 had faded. In the more recent past, the politics around policing has also undergone a transformation. The murder of George Floyd and the rise of the Black Lives Matter movement in particular have made the public more attuned to the power police wield and their willingness to abuse it. For all of these reasons, the time is ripe for a new book about what I call virtual searches, police investigatory techniques carried out covertly, remotely, and technologically, rather than through physical intrusion. Despite the Supreme Court's signals that it is rethinking how the Fourth Amendment applies to virtual searches, the case law still tends to give law enforcement quite a bit of leeway in this area. In contrast, most scholarship has tended either to demand strict regulation of new virtual search techniques or to call for their outright abolition, both on general privacy grounds and because of the impact of surveillance on racial minorities. This book stakes out a middle ground in fashioning legal responses to technological policing. It tries to take into account the implications of new technological developments, the burgeoning judicial interest in expanding Fourth Amendment protections, and the rejuvenation of libertarian and anti-racism politics, without losing sight of the fact that crime, especially violent crime, is a serious problem in this country. This book also takes a broader view of regulatory alternatives than did Privacy at Risk. That book focused on the judiciary as the main driver of surveillance regulation, and thus was mostly about the interpretation of the Fourth Amendment and other constitutional provisions. While this book also devotes considerable space to analyzing Fourth Amendment jurisprudence in the hopes of shaping its future contours, it is more attuned than the previous book to the potential of legislatures and other representative bodies to devise means of curbing government power. Whether or not the Fourth Amendment is read as broadly as I contend it should be, the precepts set forth here can inform the legislative and agency policies that we are beginning to see promulgated in much greater numbers than a mere decade ago. Virtual Searches was essentially written from scratch, although parts of it borrow from articles I published in the Georgetown Law Journal and the University of Pennsylvania Law Review, and chapters published in the National Constitution Center's A 21st Century Framework for Electronic Privacy, and the Cambridge Handbook of Surveillance Law. 1. The legislative struggle over virtual searches. The third week in January 2021 saw three developments in the law governing technological policing that cemented the decision to write this book. None of the developments was earth-shattering. In fact, all three were fairly typical, but that's the point. The three events occurring at the local, state, and federal levels are representative of today's daily ferment over what I am calling virtual searches. 1 week in January 2021. The first event occurred in Nashville, where I live and teach. In January 2021, Nashville, like the rest of the country, was in the midst of the COVID-19 pandemic, and the city was busy figuring out what to do about it. But on the night of January 13th, the focus of the Nashville City Council's Committee on Public Safety, Beer, and Regulated Beverages was automated license plate readers, ALPRs, cameras that can record license plates and, in some versions, much more. Several years earlier, the Council had passed an ordinance that prohibited operation of ALPRs installed onto or within the public right-of-way, unless they were used to help identify vehicles suspected of involvement in a crime or violating emissions standards. Then, in the fall of 2020, Councilmember Freddie O'Connell proposed an amendment that, while leaving the criminal investigation and emissions exceptions in place, would otherwise have prohibited operation of ALPRs to capture occurrences on public spaces, no matter where they were installed, a provision that many thought would apply to the use of Ring doorbell cameras and other privately owned devices that might pick up